We're going to jump right into the bills that were enacted this session that deal with a variety of workplace issues. We're going to, after we talk about the bills and the carryovers, we're going to talk about a couple of other issues that are sort of hot issues in the workplace right now, including vaccines in the workplace and what employers can or can't do, should or shouldn't do. So, Anne Marie, why don't we start off with one of the first bills of the session that dealt with FMLA, and that's LD 61 dealing with grandparents and FMLA leave.
Sure. Good morning, everybody. So I'm happy to talk about this first one. This is an amendment to Maine's Family Medical Leave Act. It was proposed as emergency legislation, but did not pass that way. So it is regular legislation that will go into effect October 18. What it does is, can we switch the screen back so I can see everybody, and will that work? What it does is it expands the eligibility, thank you, for protected family medical leave by adding coverage for grandparents. So this is your employee who is a grandparent who needs to time off for a grandchild or a domestic partner's grandchild with a serious health condition. So it is limited. You know, there's a variety of reasons for leave under the FMLA. This is limited only to a grandchild who has a serious health condition. And so what this will do is it has an odd practical effect to it. And that is that it's going to entitle an employee who is, so if you are an employer who's covered by both state and federal FMLA, it is going to allow an employee who qualifies for this kind of leave to now potentially take protected leave under Maine's law, so up to 10 weeks, but also an additional 12 weeks under federal FMLA in the same year. And the reason for that is because the grandparent coverage is not part of the federal FMLA. So that means you cannot run these leaves concurrently, which you could do for a lot of the other protected categories. So that, to me, that's the almost as important as the fact that this is enacted, is that you need to be aware that this is not concurrent leave. And so somebody who uses this leave could potentially be entitled to take up to 22 weeks in a 12-month period, as opposed to a total of 12. And again, this goes into effect October 18. So it will be very important. I'm going to try and remember for each one of these that has an action item for you. I'm going to try and remember to make sure that I point that out. And this is one of them. So you will, now, again, this only affects Maine FMLA. So those of you who have 15 or more employees are going to have to revise your handbook to be sure that you include this kind of leave as a potential eligible leave category. Those of you who have fewer than 15 employees do not need to worry about this.
Anne Marie, two things. One is, it's possible if you have a parent and a child working for the same employer, that they could both take FMLA leave for the same child, one of the children, the grandchild, the child. Is that correct?
Yeah, that's an interesting point. There isn't anything in the law that would restrict that from happening. So unlike a married couple where there is a specific prohibition on two people taking leave at the same time for the birth of a child, there is no such limitation here as it's written. So yes, you could have one employee who is the grandparent of the child, of a grandchild with a serious health condition, taking leave. And you could potentially simultaneously have that child's parent, if they also work for you, taking their time for the serious health condition. Yes, I think that's true.
And that's something that we brought up to the committee and asked them to try and prevent that kind of double dipping for an employer, because again, you're talking two absences perhaps simultaneously. They didn't do it. And it's unfortunate. So that lack of definition comes back to haunt us, but they were just not interested in it at the time. The one thing I meant to say when we started, and I apologize, is you'll notice that you're all muted. That's purposeful. But if you have questions as we go along, would you please enter them into the chat function, which I'm sure you're all familiar with by now, and we will ask the questions at the time they're entered rather than holding them to the end. So we'll just keep a rolling list of questions and try and answer them as we go along.
So Peter, before we leave that, to follow up on your point, so not only potentially could the grandparent and the actual parent take the leave simultaneously, but potentially if both grandparents are employed by the same employer, that prohibition against two married couples taking leave at the same time does not specifically show up here. So it's possible that both grandparents could use their leave at the same time.
Yeah, and I know that the legislature looked at that as sort of a specious argument, but the reality is there are mills and there are employers in this state that employ families at the same time. So it's not out of the realm of possibility that something like this could happen. The next bill, which had a long and sort of tortured path to enactment, was LD 1167. That's colloquially known as ban the box. And now Maine joins about 30 other states across in the United States that has a ban the box provision. In its shortest form, it basically forbids an employer, unless they must, as a result of either state licensing or federal requirements, they are forbidden from asking the question about a criminal background or criminal history or conviction of a crime on either a hard copy or virtual job application. And there are some other provisions that go along with it. Anne-Marie, do you want to talk a little bit about those?
Yeah, so what this does is it specifically says that an employer, which just so you know, is defined as including a person acting in the interest of an employer directly or indirectly. So that's the first point I wanted to make, because sorry, the question popped up and I got distracted for a sec. Because it's possible that somebody like a leasing agency or a hiring company could also be standing in the place of the employer and would have to limit their applications in the same way. I think that's probably true. But what it says is the initial employee application form, and it specifically uses those words, the initial employee application form, is not, you're not allowed to ask for criminal history, record information, or state on the form. So it's not just, you can't have that box anymore where you have to check off if you've ever been convicted of a felony. But it also says that you cannot state on that application form or in an advertisement or specify prior to determining a person is otherwise qualified for the position. So I think that's pre-conditional hire is what that means. That a person with a criminal history may not apply or will not be considered for a position. So the basics from my perspective, this is all because of what we've been hearing from the EEOC and some other agencies for a while now, which is an employer shouldn't automatically exclude somebody just because they have a criminal history. And they have told us for a long time that you as employers need to go through an individualized assessment for each person, regardless of whether they say they have a criminal history or not, because it's entirely possible that somebody has had a conviction in the past that has absolutely no bearing on either their ability to do your job or the PR or any of the other concerns that are often raised about that. So this is basically solidifying that now you're just not going to be able to have that information. At least arguably until there's a conditional hire done, and then you would still be able to do the regular background checks. Now, it also addresses interviews, and it says that you can't ask it on the application or in the advertisement, but it does say that in an interview, you may inquire about the criminal history record information, or you may inquire once the prospective employee has been deemed otherwise qualified for the position. So again, I think that means, the interview part is interesting to me because a lot of times, you wouldn't have made a conditional job offer before an interview, because the second piece of that is clearly meant to be after a conditional job offer. But according to this, you may ask that during an interview. If you do that, and if you make that inquiry at any time, you are now supposed to give the prospective employee the opportunity to explain the information and the circumstances regarding any convictions, including post-conviction rehabilitation. So again, I think this is really just solidifying what the EEOC has already said you should be doing, which is to make that individualized assessment once you have that information and determine whether or not it actually has an impact on your hiring. And you can't just exclude somebody as a matter of course just because they have a criminal background. There are exceptions, which Peter pointed out. Those are for, there are a couple listed there, for anybody who is under a law or regulation that requires you to have a criminal background check, or if you're, well, there's some other, or if, for instance, if a conviction would automatically exclude that person from working for you. So there are some exceptions for those of you who must have that information by federal or state law. So again, this is one of those things that you have an action item now, and you need to go back and ensure that your application is consistent with this. And also, I think an important piece of this is to make sure that you train whoever is conducting, well, I mean, you can ask it during an interview now, but I think you just want to be sure that anybody involved in the hiring process is aware of what this says you can and cannot do.
So a couple of things as both background and as a sort of, I think, a harboring of things to come. The sponsor of this bill very much wanted to make people who have been convicted of a crime a protected class for the purposes of hiring and employment. We said absolutely no. We're not going to give convicted criminals a right under the Maine Human Rights Act that the average person doesn't have. And so we went back and forth around this issue. And I will say this, with respect to the interview process in particular, the idea was that the employer would have the ability to ask the question of a prospective employee, of an applicant, when they were in front of them, so as not to ding somebody out of the box before they had a chance to perhaps present themselves as a good employee. There are algorithms, particularly in online job apps, where if someone will click, you know, they've been convicted of a crime, they're automatically dinged. And so the idea that the sponsor behind the, the sponsor had behind the bill was, if you get a prospective employee in front of an employer, and even if they've been convicted of a crime, they can still make their case that they could be a viable and contributing employee to that employer's workplace. It's hard to argue that, argue against that. It's still the employer's right and ability to say thank you, but no thank you to that person. You could end the interview right there, I would argue, if you wanted to, as long as you document that you gave the person their 5 or 10 minutes to explain themselves. What we don't like, and what I still think is problematic in the bill, is how do you define give the employee a chance to explain themselves? How long is that? Is that 5 minutes? Is that 10 minutes? Is that something in writing? I worry about what that means. And I think there'll be legislation, probably not in 2022, but probably in 2023 to expand upon this issue. Someone asked a question when this becomes effective, and that's, I believe, October the 18th of this year. I also think there may be some rulemaking around this at the Department of Labor, but I'm not completely sure on that one. That was me, sorry, wrong button. Any other questions? Anne-Marie, you want to add anything to that?
Just that there is, although some of these bills we're talking about do not have their own enforcement procedure, this one does. And it has a procedure by which you can be fined a forfeiture of somewhere between $100 and $500 for each violation. So take this seriously. And also, I just want to, give a reminder, this doesn't change anything about the fact that you are still not allowed to ask about arrests, but not convictions. So don't try and get around it by going backwards, because the EEOC has always been clear that you're not entitled to ask about arrests at all. And I don't think this would change anything about the infamy or however you're doing your criminal background checks. Even if you were to ask the person, in an interview. I don't think that's any different necessarily than how we previously asked on a application. And I think you still would want to go forward with the informe check, because you need to be sure that that person has been forthright with everything. Even if they revealed, if there's one thing, you just want to be sure that you've done your due diligence for background checking to make sure there isn't anything else out there.
The next bill we're going to talk about is a bill that was actually before the legislature prior to their adjourning due to COVID in March of 2020. And this year's version was LD 1294, and it's a bill that gives employees protection rights under the Maine Human Rights Act with regard to employment if they have ever received a protection from abuse order. The Judiciary Committee considered this bill. I think it was on its way to passage in 2020. It came up this year. We did express concerns with it for a variety of different reasons. They really didn't address those concerns, and nonetheless, they passed the bill out. It will become effective in October of this year. Anne-Marie, you want to expand upon that?
Yeah, I mean, there really isn't too much more to say. That's in fact exactly what it does. It just expands the protections of the Maine Human Rights Act to cover. The language is an applicant who has sought and received an order of protection under the Protection from Abuse Order for domestic violence victims, and it's not just applicant but employee as well. So I'm not sure. I mean, Peter, do you have any sort of inside knowledge about whether there was a particular problem that arose that created this? Because it seems like it sort of came out of the blue and is very specific.
In both cases, when the bill was introduced, it was by the same legislator, Donna Bailey, who was the House chair of the Judiciary Committee in the 129th and was I believe that she may have been the Senate chair this year. I can't remember. Our biggest concern with it is this, and Anne-Marie, I'd be interested in your reaction to this. If you receive a protection from abuse order in one situation, there is, the hope and the idea that it's that relationship that resulted in a protection from abuse order. You will be moving on from that, and things will change in your life as you go forward. And you may enter into a different relationship that is healthy and doesn't have anything to do with that protection from abuse order. And yet it's still there and it's out there. Does that provide you from that going forward basis with this kind of protection, according to the Maine Human Rights Act, for the remainder of your career in the workplace or not? What would your guess be?
Well, it doesn't specify that. It just says someone who sought and received. So it could be in the present time period for an order that's in effect at that moment. Or I could see it being, that's why I asked the question about the background, because I wondered if somebody had raised a specific issue about being retaliated against by an employer for just the mere fact of having a protection from abuse order in the past, which seems odd to me. So that somebody would retaliate on that basis. The one thing I was thinking, because I've had this come up before, and that is when you have both of those involved people in your workplace. So in other words, the person who sought the protection from abuse order is your employee, and so is the person from against whom the order is sought. And that creates a huge problem, because oftentimes the orders have a geographical limitation, so that person can't be within a certain amount of space of the other person. And then a lot of times they simply can't work in the same workplace. And so I've gone through with employers about what to do, and how do you fire one of them and not the other, or how do you go about handling that? So I wondered if maybe there had been situations where the person who had sought the order was the one who felt like they were being retaliated against by being terminated because they can't work near the other person.
No, that wasn't the case in the public hearing. The issue around employers following the law regarding protection of jobs and workplace leave as a result of the need to seek medical help, the need to seek a protection from abuse order, issues with domestic violence. To my knowledge, there's almost no issues with that out there in the workplace. I never hear about it from employers who aren't willing to comply with the law. And so I'm not sure why this is out there, why it came along, but it is. And it may need some clarity on a going forward basis. But honestly, I don't know any more about it than you did. We were the only group to submit testimony in opposition.
You know, and the other thing I wonder is that the language in the amendment is very specific to an applicant. And so I'm actually questioning, would this apply to a current employee? Was there any discussion about that distinction?
Not that I'm aware of, no.
Yeah, so we'll have to sort of flesh that out to see who this runs. I mean, you know, it may not come up very often, but just to be sure about who this covers.
We do have a question going back to the LD 61, the grandparent leave. And the question is this: would there be the same limit on the total weeks used by parent and grandparent and or two grandparents? So use a total of 44 weeks, or is it shared 22 weeks? I would say it's 44 weeks.
44 total.
Yeah.
Well, no, I mean, let's make sure we're clear about that. This is not, a person is not entitled to this same leave under the federal FMLA. So
Right.
the most that any employee can get for this covered leave law amendment is 10 weeks in a 2-year period, because that's all the Maine FMLA permits. So for grandparent leave, nobody's going to get more than 10 weeks. The only time they would get combined leave of 22 weeks is if they use the grandparent leave, and then in the same leave year, they needed time that's covered under the federal FMLA, and then they would get an additional 12 weeks because you can't run them concurrently.
But I think one of the questions I think is, in a covered employer, if you had two parents and two grandparents working in the same employer group, could they each combine use 10 weeks of leave to take care of the child? So in other words, in that weird conflagration where you have two parents and two grandparents working for the same employer, could they each access 10 weeks of leave? And I think the answer to that question is yes.
I think so too.
The next bill that we're going to talk about is a resolve. Actually, let's skip over that one and let's do the big one, because I know unemployment insurance is a very hot topic right now, with the $300 set to expire in a week. And that bill is 1564. There were two bills that were put in during this legislative session, one by Speaker Fecto and one by the administration through Senator Vitelli. And I was contacted and had a meeting with Laura Fortman, who's the Commissioner of the Department of Labor, prior to the bill's public hearing. We didn't get a lot of notice as to what was going to go in the bill, or what was, as the bill was being drafted. We just saw the bill as it was being presented to the committee. Speaker's bill was a bill that was put together by employee advocates in the labor unions, and was fairly expansive. Without getting into the minutia, I'll let Anne-Marie talk about it. It is probably represents one of the more significant reforms to Maine's unemployment system in the last 20 years. And unfortunately, I was part of the early reforms 20 years ago in 1999 and 2000, where the employers were brought to the table and made part of the bill writing process. And that did not happen this year. So what you have is a law that was enacted without the support or the benefit of employer input, at least not until the very last minute. And we only had minimal say in the legislation. It's not as bad as the Speaker's bill. It's not as good as I think the bill could be. I think there are going to be problems for the employer community going forward with it. I think it is going to cost money, and it does make some fundamental changes to the way UI will be available to people. Much of it, like much of the legislation we dealt with all session long, is directly related to the pandemic. So with that sort of bleak introduction, Go ahead, Marie.
Well, I'm afraid I don't have anything more positive than that to add. So let's go through. There are several things to talk about here. So let's just take them one by one. So the first thing that the amendment does is it changes the definition of partially unemployed in terms of when somebody will qualify for benefits. So it used to say that somebody's considered partially unemployed if their wages from any source for any particular week are not $5 or more in excess of the weekly benefit amount, okay? This changes that to say that if the earnings have to be $100 or more. So I can tell you for 100% certain that math is not a strong point for me, but I think even I can figure out that that means that you're going to have more people who qualify as being partially unemployed than you did before, because that's a pretty big jump from $5 to $100. Peter, am I reading that correctly?
Yeah, yes, that's correct. Again, on that one, I think the issue was, I think the idea was to encourage people to get part-time jobs and thus diminish the impact on the fund. But again, you know, there's theory and then there's practice. And so I don't really know how this is going to work.
Okay, all right. And so then the next change is, this is the big one, so we may as well get this out of the way. So you know that there are a list of reasons why somebody will not be disqualified from getting unemployment benefits, even though it seems like on its face sometimes they should be. But legally, I'm not making any judgments, just legally. And so those include, for instance, if there's an illness or disability in the family and the person has to leave to care for that person, or if they move out of state or move to a different residence, or if the spouse moves. So they have added a category to that list of things that will not disqualify somebody from getting benefits. And this does seem directly related to some of the issues we face in the pandemic. So the new reason is if the leaving from employment is due to the unexpected loss of child or elder care for which the claimant was not at fault and for which no work alternatives such as changes in hours or a leave of absence or alternate child or elder care options are available, despite good faith efforts made by the claimant to resolve the issue and continue working. So there's a lot in there. It seems to me that this came directly from the problems that a lot of us faced last year with childcare, school not being in session or being remote, and then childcare not being available. So someone in that situation, but it doesn't limit it. I want to be clear, it doesn't limit it to any pandemic related condition or anything else. There are no limits on this. It can be for any reason due to the unexpected loss of child or elder care for which the claimant was not at fault. So this would be not only a pandemic related situation, but if my child care provider just simply closed down and all of a sudden I don't have care, I am not going to be disqualified from unemployment benefits if, number one, it was unexpected, and number two, I have made efforts to find an alternative and there isn't anything else I can do. So as an employer, you may now be faced with requests for leaves of absence to deal with a situation of someone who's temporarily not having child care or elder care. And in that case, if you are the one who says, I'm not going to allow a leave of absence for that, then the person is likely going to qualify for unemployment. I think that going through the pandemic, that a lot of people in this situation were determined to be eligible anyway under some of the relaxed standards. So I think this seems like it's just sort of codifying what the practice has been for the last year, but you probably know better as employers than I do. Peter, was there?
There is one more part of that. It's not just child care and elder care. It's also unexpected loss of transportation. It's not just that. If memory serves me correctly, I'm looking for
that's not in the final. I know that
Then
was part of,
they must have pulled it then. I did not know that.
because I know that was part of the original, but in the final version that I'm looking at, that transportation is not included.
That's then they did that at the last minute. I know that the transportation issue was a huge issue for us because it just meant that somebody could just say, I don't have access to a car, I can't work, now I'm eligible. And our issues with both of these things is in the past, when someone's been eligible or become eligible for employment, it's, you know, as a result of something the employer did. You got laid off, you get your hours, you know, you had a loss of hours, you got fired, whatever it is. But the childcare issue and in particular the transportation issue were both policy issues that were totally out of the hands of the employer. They had no impact on that whatsoever. And yet the employer was going to be, their people were going to become eligible for UI and their experience rating was going to be impacted by it. So that was a big issue for us. I did not, I'll be honest, until right now, because I've been looking for it, I did not realize that they had removed transportation. That is good.
And so if you take that to its conclusion about the impact on your experience rating, this sort of has the effect of putting pressure on you as an employer to permit people to have leaves of absence to deal with these loss of child or elder care situations, as opposed to laying off or terminating that person, which is an interesting sort of twist to it.
The other thing that was a very big deal to the folks involved with the passage of the legislation was this implementation and establishment of a peer navigator program. And originally the peer navigator program was much more expansive and dealt with assisting people in access to unemployment insurance benefits. And it taxed employers through the speaker's bill, it taxed employers a small amount that then the department would use to contract with people familiar with the unemployment insurance system. In other words, people who are not employer groups, but are more likely advocate groups or even organized labor. And so we'd be essentially, employers would be essentially paying them to work against the best interests of the employers when it came to unemployment insurance. As it ended up, the peer navigator program went through a series of amendments. And now it really focuses on new Mainers, people who have limited access to job opportunities, et cetera. It remains to be seen what the Navigator program looks like, but here's what it's not. And this is something that we also squawked about, and that is it's not a Navigator for small businesses. As much as employees had issues navigating the unemployment insurance system during the pandemic, so did employers, particularly small businesses without HR folks, and understanding how the system worked for them or their employees. And what we said to the department and the committee was, if you're going to make a Navigator program, it should be available to everybody, because small businesses have as much problem dealing with the complexities of the issue as individual employees. Well, all we got out of this in this bill is the department has agreed to look at how the Navigator program might work for employers in the next 12 months. I don't think much is going to come of it. We'll wait and see. Anything more you wanted to touch on that, Anne-Marie?
Yeah, there's one other piece of it that it's important to me, and it will be to you folks in the event you have a claim and something happens. So there was a change, a little bit of a change to the process by which you can challenge somebody's award of benefits. Now, this does not impact the original process, the original decision-making procedure, but it does now say that once a claimant is already receiving benefits, so you probably know there's a provision in the law that says that if something new comes up, like for instance, you determine that they're actually working somewhere else, there is a process by which you can bring that to the commission's attention and present that information to them. So they've made it's a small change, but it's a big thing too. It used to say that they would make a determination based on written statements and evidence presented by people who personally appeared in front of the commission. they have changed that to take out the appearance piece of it, and now it's focused only on participating by telephone or email or other electronic means. So basically what this is saying is that from here on out, if you're challenging an award of benefits that's already in effect, there isn't going to be an in-person hearing. You can submit your information by writing or by email, or they may do a Zoom. And I don't know if this is intended to address ongoing pandemic potential related issues, or whether it's just too burdensome to have in-person hearings for these kind of situations, but that's one twist that's also in there. And then there was a change to the dependency section. So it used to say that in no instance may a dependency benefit be more than 50% of the individual's weekly benefit. They're changing that to say 75%. So they're increasing the amount of a dependency benefit. And it also says, so it took out a section about dependency when a spouse, so it used to say that if there's a dependent and the employee, your employee's spouse is employed somewhere full-time, that limits the benefits the dependent can get. They have struck out that entire paragraph and added instead that only one individual is entitled to a dependency allowance for the same dependent with respect to any week. Which, I mean, the two don't seem to line up exactly. They almost seem like they're separate issues. So there's no more exclusion if a spouse continues to work full-time, but now they're saying that only one person is entitled to a dependency allowance for the same dependent. So I guess in other words, if the employee and their spouse are both working, both of them are not going to get the dependency benefit. So that's the last sort of major alteration.
Let me touch on a couple of questions that we've gotten. I was asked, is the amendment for unemployment benefits in regard to childcare going to be permanent or just something we will see during the pandemic? Right now, it's permanent. It's in statute. We need to be amended or changed if it was going to be, on a shorter of a different duration. And then there was a question regarding the ban the box legislation. So we cannot ask if they have been convicted of a crime on the application, even if we provide a space for an explanation. I would say the answer to that is correct. You cannot.
You cannot, not on the application.
No. It needs to come off the app, unless you're required to because of state licensing, or you're in the banking world and you're required under federal banking laws to ask those questions, then that provides you with some cover. Otherwise, for anything else, all other employers, it's got to come off your app, whether it's a hard copy or electronic.
Yes, and also keep in mind, for those of you who are required under state or federal law to ask about criminal convictions, it does specify that while you are still permitted to do that, you are only entitled now to ask about the ones that you need to know about. So in other words, if to get a CDL, to hire a CDL driver, you need to know if they've ever had a drug conviction, for instance, but you don't care about any other kind of conviction, you have to limit your question only to that kind of conviction. So I would encourage those of you who are covered by such state or federal law and are permitted to ask certain questions, make sure you go back and look at the actual language of the amendment. And I'm sure that we can either, you'll have these up, Peter, on your site, or we can get them to people if they have trouble finding them, right? Because I think it's important to look at that language.
Yeah, we could try and post links. I think if you go to our newsletter, if you're a member of the chamber and you go to final summary, there are probably hot links in the database that will take you to it.
Yeah.
Let me.
So people know also, none of these are emergency legislation, so
right.
They all are effective October 18, is my understanding. Is that right, Peter?
That is correct. 90 days after the legislature adjourns, sign or die. So after October the 18th, they will be law.
So don't wait for the end of the year to think, well, I'll amend my handbook and all my forms, for January 1, like I usually do. This is going to have to be done by October 18.
I know that Anne Marie has a number of bills she wants to touch on very quickly before we go to carryovers. I just will say there's one other bill, 1559. This is a resolve the legislature has had before it for a number of years, and they finally had the votes and the money to pass it. And it is designed to put a study group together, as well as hiring an actuary to determine whether Maine could set up its own paid FMLA leave law and what's the word I'm looking for? Program. I don't know how this is going to proceed. They do have the money. For years, we said you can't do it without an actuary. You need to find out cost, uptake, taxes, funding, et cetera, et cetera. They did get the wherewithal financially to do this. The committee has not called for a meeting yet. We'll have to wait and see. I believe the resolve is also effective October the 18th. So I just want to touch on that real quickly. Anne Marie, you have a couple of bills you wanted to bring people's attention to.
I do, yeah. So one of them is LD 183, which is the act to establish Juneteenth as a paid state holiday. So this does not obligate you as a private employer to do anything. It doesn't require you to make that your own paid holiday. I just want to be sure everybody's aware of it in the event that you follow paid holidays and choose to amend your policies to recognize June 19. This would obviously be for next year and thereafter. But so I just want to be sure people were aware of that. And then there's LD 610, excuse me, 610, which deals with recovering overcompensation paid to an employee. This is a fairly rare situation, but it does happen. And what this amends it in a couple of different ways. The primary way is to clarify that if you were the one who made the mistake, you as the employer, and overcompensated an employee, you are only entitled to recoup what you have overcompensated for the period of the prior 3 years. So there didn't used to be a limitation on how much you could try to get back, but they are now limiting it to 3 years in the event you're the one who made the error. I think that's the primary change for that one. And then I wanted to mention, I'm sure that none of you are already doing this, but if you are charging employees for direct deposit of their paychecks, you cannot do that. And I know that I have questions about that periodically and have long said don't do it because there's some other provisions in different areas of the law that discourage it, but now it's absolutely prohibited. So that's LD 1106. You cannot charge a fee to direct deposit somebody's payroll check. And then there's LD 1489, which is the service industry tip minimum increase. So for those of you who are in the service industry and you compensate through tips, you should know that the amount before an employee, well, it increases the amount of tips somebody has to receive in order to be considered a service employee. It's a big increase from $30 a month to $175 per month. So I would encourage you to look more at that if you are fall within that category. I know we're just shooting through these, but we have a lot of other stuff to get to. So, and then the last one I wanted to mention is there are some changes to the Maine Human Rights Act. They probably don't immediately impact you and may not have any practical effect at all, but I do want to just make sure that people are aware that they're there. The primary change, well, two primary changes. One is it added familial status as a category under which someone cannot be discriminated against because of. Familial status has been in the law, and it has included living with or caring for minor children. It's now going to also include living with or caring for adults who are unable to meet the essential requirements of care for themselves, basically. So elderly people living within the home or disabled family members is now included within that familial status definition. And then the other thing it does is it has taken gender identity out of the sexual orientation umbrella, if you will, and listed it as a separate category. The commission has been clear that this isn't really a change in and of itself because gender identity has been deemed to be covered as part of the definition of sexual orientation. But for matters of simply clarification, I think, and recognition, they have removed that that heading and made it its own separate category of gender identity. But it shouldn't have any practical effect because you were already not discriminating based on gender identity under the sexual orientation umbrella. So those are the primary changes to the act.
So that's what was enacted by the legislature and will become law in mid-October. So the question is then, what are we looking at in the next legislative session? And as usual in the legislature, they often save the most difficult and the most controversial bills for last. And that is certainly the case in the upcoming session. There are, I think, 2, 3, 4, 5 carryover bills, all of which are extremely important to Maine employers. And we'll start with 225, which is an act regarding the treatment of vacation time upon the cessation of employment. This would require employers to pay employees for any unused time when they leave employment, whether you have a policy that says you'll do so or not, and it includes the new Earned Paid Leave Act. Anne Marie, you want to add into that?
No, I'm not sure that I have a lot more to say about that than that.
It has been an issue that I know the governor's office has had concerns with. It's part of the reason it didn't get anywhere. I had labor representatives reach out to me. One of the things I've tried to impart upon folks who are supporting this bill is if you do this, employers are gonna limit the amount of carryover vacation an employee can incur. They're just not gonna, because their accountants are gonna tell them, you can't have all this financial liability on your books if you're allowing people to book, 10, 15, 20 weeks of vacation. It's just too much of a liability. And I will say the bill doesn't limit an employer's ability to adopt a paid time off or PTO type leave. It doesn't limit you to capping the leave, and it doesn't limit you to the ability to institute a lose it or use it policy, none of which are particularly good for the workers, for the employees, but with the type of financial liability the bill sets forth, particularly around earned paid leave, which was not part of the deal when that was discussed 2 years ago, it's a problem. So that's, go ahead.
So scary. It's just so scary. There's so many elements of it that you just get to the point where you don't want to sort of focus on it until we know what they're going to do, Right.
Exactly. And to that end, the next bill is LD 607, which is an act to restore overtime protection for Maine workers. Anne Marie, you want to talk about this one?
Yeah, let me see if I can find it in my materials quick here. Yeah, so it raises the minimum salary for those employees who are considered exempt from, over the course of a period of time, I think going up to January 2025, it will extend it up to 55,224. And it bases those on the Department of Labor, Bureau of Labor Statistics over that time period. So that's a pretty big jump from where it is now, and it's going to exceed what the standard is under federal law as well. And so you'll have to comply with this, and that means we're going to go through that process that we went through a couple of years ago when there was that enormous shift in what was considered exempt or non-exempt, and may require you to evaluate whether or not you're going to keep people as exempt or try to alter job descriptions and responsibilities.
Yeah, to put it in perspective, we would have the highest salary threshold in the nation. California actually splits their threshold between an employer with more than 500 employees and an employer with less. And even in that split, we'd still be higher. I think this is a disastrous bill. And again, it would be one thing if we were well below the federal standard or even at the federal standard, which I would remind everybody, I'm sure you know, was just changed under the Trump administration. But Maine's salary threshold will go up every year because it's tied to changes to the Maine's minimum wage. Our salary threshold is 3,000 times the state's minimum wage. So every year the minimum wage goes up, and it's indexed yearly now by the CPI, so does the wage threshold. So we were at 36,000, now we're at 36,450. It'll go up again, probably 1 or 2% next year. So we already have an escalator built in. I had hoped this bill would just go away, but it is not. And there is a real push, particularly by organized labor, like the cash out of vacation time, to pass legislation in this area. Part of the reason they carried it over is they wanted to see what the feds would do around this issue. I don't think they're going to do anything with it. The third bill is LD 965, an act concerning non-disclosure agreements in employment. I'm going to let you take this one, Anne Marie. I know what our issue was with it, but you have more experience in this area.
Yeah, so the bill as currently stands proposed would prohibit you from requiring an employee, an intern, or an applicant to enter into any contract that waives or limits any right to report or discuss any discrimination, retaliation, or harassment that occurred in the workplace. So in other words, while at the current time, you're entitled to enter into, for instance, settlement agreements that prohibit a person from talking about that. And in fact, that's often a very important part of a settlement or a end of employment agreement. This act is going to prohibit that under certain circumstances. There's some caveats to it and whatnot, but I think it's going to have, if it passed as written, it would have a pretty significant impact on whether or not you even wanted to enter into a settlement agreement, knowing that it isn't necessarily going to achieve what you want, all the things you wanted to achieve. So I don't know if this is going to be manipulated in its language before it goes forward again, but as it stands, it's a little scary.
So as a background, very quickly on this bill, the governor does not like this bill as in its current form. It actually got to her desk in the 129th. She had it recalled, and it was one of those bills that died when the legislature adjourned in March of 2020. It's back again, and it's not any better than it was 2 years ago, and the administration still has issues with it, which is why it was carried over. That's where that one stands. The next two bills deal with litigation and fines. 616, an act to increase accountability for wage violations. I can do this one very quickly. They want to increase penalties from the current $100 to $500 for a first, Chapter 7 violation, and each additional violation would be increased to $500, but no more than $2,500. So there's a fairly steep incline in the penalties for workplace violations, which, if they're purposeful and willful, is one thing. The problem is the bill doesn't delineate between a mistake and a willful violation regarding wages. And we tried to impart that concern on the Labor Committee, and they really didn't listen to us. The Department of Labor was somewhat of a help in the sense that they said they would step in, and this is attached to rulemaking and ultimately the department's authority to levy these fines against violators. And if it was a mistake on the part of a small business, then they wouldn't perhaps be open to the $2,500 fine, but only the $500 fine. But here's the other thing they didn't fix. Let's say it's a mistake in withholding to employees in the workplace, and there are 15 employees, and all of them have a mistake in their withholdings. Is that 15 violations or is that one violation? And neither the department nor the committee could answer or would answer that question. And that's significant, because if it's one violation, then you're talking a $500 fine. If it's 15 violations, you're talking a $2,500 fine up times, 14. So we thought there really needed to be clarity on that issue, and we didn't get it. And I think it's part of the reason the bill ultimately got carried over.
It's actually, and it gets worse than that too, because it also contains that provision that's in our unpaid wage law right now that says if the employee gets a judgment for the wage violation, they get damages of twice what the amount owed is. So that gives, there's a lot of motivation for people to pursue an unpaid wage claim now because it's a treble damage situation, and this is exactly the same thing.
Yep. The last bill is 1338, an act to prohibit employers from retaliating against the use of earned paid leave. This bill, that's a new title for the bill. As the bill was originally drafted, it basically indicated that every section of Chapter 7 in Title 26, which is sometimes referred to as Workplace Protection Act in Maine statute, was a protected right of the individual employee, and therefore an employer's violation of that right could result in a private right of action against the employee, against the employer, brought by the employee with outside attorneys, with all kinds of penalties and fines and damages that would be available to them. And that is very different from the way much of the wage penalties are dealt with now. As I just indicated, the department is the one that levies the penalties and makes the decisions on what those are going to look like. Obviously, there was a lot of concern on the part of us and others in the business community. We opposed it. They ratcheted it back to just employers who violate the use of earned paid leave, whatever you want to call violation of the use of earned paid leave. And this is something that many of the labor groups wanted through rulemaking when the earned paid leave law was going through that process before it became effective in January of this year. They wanted teeth in the law, and they in particular wanted private rights of action for any time an employer denied the use of the leave by the employee or retaliated against the use of the leave because the employee took it. The governor was not supportive of this proposal, but what the department is supportive of is taking a look at the penalties and fines currently in Chapter 7 and revisiting them and maybe updating them. And honestly, that's something we said, okay, if you want to do that, as long as employers get to be at the table while you have those discussions. But as far as, this private right of action against employers for the around earned paid leave, first of all, there are issues in the rulemaking which are purposefully unclear for flexibility purposes. What is adequate notice? What is an undue hardship on the employer? Those kind of things. All that becomes fodder for litigation under this bill. And so at the end, it looked like it was going to be enacted, and then it was pulled at the last minute and it was carried over. Anne Marie, you've taken a look at the language. What are your thoughts?
I agree. You're just begging for massive litigation and in unfair ways, I think, to an employer, because as you said, especially the earned paid leave is vague in a lot of different ways. And we're all trying to work through how best to apply it and what things mean. And until we have some more direction, hopefully at some point from the department, we're not going to know that. And this puts you as an employer squarely at risk of litigation over something that was unclear to begin with. We may prevail and we may get a good decision about it, but you're also going to be out of pocket quite a bit of money to try and enforce it. So, it doesn't seem like the right solution to whatever the problem is.
Well, and if you think of the size and the scope and impact of the earned paid leave law on the Maine workforce, we're talking employers with 10 or more employees or more than 10 employees. You're talking full and part-time. It's right for, plaintiff attorneys to cull through these, the massive amount of impact in the workplace and employees impacted to try and create a practice around this issue, which I'm sure you could probably do, because employers, even today, aren't necessarily aware that they should be complying with the earned paid leave law, which is a scary thought, but it's true. So anyhow, we wanted to bring these 5 bills to your attention because these are big issues that didn't get solved in the 130th, and they're going in the first session, and they're going to be dealt with in the second session. The teaching moment for me this last session was our ability to win the fight around 553, the end of employment at will in Maine. You know, at the end of the day, I was reminded that grassroots outreach by folks that are on this call and local chambers and others made the difference. And in a very progressive legislature, we were able to defeat a very progressive bill. And we were able to do that because legislators heard from people. Around these 5 bills in this next session, they're going to need to hear from you again. And that's why we wanted to put them on your radar screen so you could be prepared to engage if we ask you to around any one of these 5 bills. So that's our function here. And I don't know if we have any outstanding questions, Anne Marie. I will look. There might have been one. Oh, the number of the LD for the Maine Human Rights Act changes with respect to gender identity. What was the LD number again on that?
1688.
1688. So I don't see any more questions in chat, and I think we've reached the end of our presentation. Do you have anything you want to add, Anne Marie?
No, I'm not about the legislation unless you wanted to talk a little bit about vaccination issues.
Oh yeah, we did want to talk about that. Thank you for reminding me. Yeah, please go ahead.
So we talked about the fact that people might want to hear a little bit about this whole vaccination status with everything that's going on in the world right now, and what the rules are about whether you can require employees to vaccinate or not, because certainly I get the question on a daily basis. So we just wanted to clarify, as an employer, you are entitled to require your employees to vaccinate. The exception to that, as I'm sure you've heard a million times, is if somebody raises an issue of a protected covered disability under the ADA or a religious accommodation request. And so you will have to deal with those just as you would any other request for accommodation. But short of that, you are entitled to require people to vaccinate. There had been an argument raised that because the vaccinations were not approved and were under the EUA standard, which is the emergency authorized use standard, that you could not require people to do it. That's not true, number one, because the Department of Justice issued their own memorandum saying that is not a basis on which people can refuse to be vaccinated if an employer requires it. And number two, because at least now it's moot with regard to the Pfizer vaccination, which has now gotten final FDA approval. So that is not a reason that you would be prohibited from requiring. I touched the other day on, you know, what does all this mean in terms of the CDC and OSHA and the state of Maine, and what are they all saying? So none of those entities have said that you are not permitted to require somebody to vaccinate. And in fact, certainly with regard to OSHA and the CDC, they are encouraging employers to encourage their employees to vaccinate. As a caveat to that, I did want to just point out that, and I know we've said this many times before, but if as an employer, you do require your employees to be vaccinated, you will face potential workers' compensation issues if somebody develops a problem because of the fact of receiving the vaccination. So if somebody gets a vaccination that's given incorrectly or has a bad reaction to it, and you are the one who is requiring that to happen, then that likely will be a covered workers' compensation issue. So I just want to make sure employers know that when they're forming their policies. But otherwise, you know, I think what the primary argument I hear on the other side is we are not going to sort of legislate morality or whatever you want to call it, and we're going to continue to leave the choice up to individual employees. And of course, that's okay too, as long as you're following and continue to follow the guidances from the CDC and OSHA for both vaccinated and unvaccinated people in the workplace. So I mean, that's like a small little tiny nutshell of all of this stuff. I don't know if people have specific questions about it that we can address for them.
I've got one. Are you allowed to ask if a potential employee is vaccinated?
Well, that's a good question. I mean, there isn't any specific prohibition about asking that, except that I would encourage you to have an objective reason for asking. So in other words, if your policy in your workplace is that you're going to follow the quote unquote recommendation from the CDC and only require non-vaccinated people to mask, no, if you are choosing to only require non-vaccinated people to mask and not following the recommendation from the CDC, which is that everybody do it when we're in a higher substantial area, and somebody is unmasked, then you may ask to confirm that they are vaccinated to ensure that that's the reason why they are unmasked and that they are following your policy. So I think my only hesitation in saying don't ask everybody is that you may get an answer from somebody that gives you information you don't want to have. So in other words, somebody may say, well, I'm not because I have a physical disability and that's why I'm not masked, because now it's out there. And if negative job action or something were to happen, then you might be accused of having done it on that basis. So you may just get more information than you want.
I've got a question. Dental clinics are required by executive order to vaccinate. Still workers' comp at adverse reaction.
Yes.
On the workers' comp issue.
Will depend on, yeah, it will depend on the ALJ and the decision they make, but I think the fact that you're mandated to do it wouldn't change the fact that it's in fact, it's part of the employment.
On the issue of workers' comp, we had a very quiet legislative session around comp for, I think, a variety of reasons. What I don't know is if that will change in 2022. It is harder to get legislation through, but comp would be one of those things that there's potential around. And the one thing that I think we've all been watching is there a correlation between legislation on comp and the pandemic and coverage and workers' comp claims associated with COVID-19. As far as we can tell, looking at how the workers' comp board reports back, most of the claims that have involved COVID-19 have been paid by the employer or by the carrier, primarily because they don't involve lost time. They're usually med-only claims. And most of the claims have occurred in a healthcare setting, and the healthcare facility has just gone ahead and accepted and paid the claims. So we don't know if there's grounds for legislation around workers' comp and workers' comp claims and the paying of those claims or not. At this point, we don't think there is, but it's the legislative session, so you just don't know.
I mean, I agree with you that most of the claims I've seen have been healthcare related and have been voluntarily paid. I do have some in dispute now that are in different kinds of facilities, like retail, for instance. And the bottom line issue is the same as it is in any other causal relationship, and that is, how does the employee prove that this arose out of the employment and not because they were in, the grocery store or the gas station or kids' daycare or anywhere else they might have been except at work? And I think that that's almost impossible. I mean, I may regret saying this, but it seems to me that that's such an issue of proof that's hard to meet that it would be, it would be stunning if there was legislation to say that you're presumed to have been exposed at work when there are a million other places where you could have gotten it. So unless the medical information changes and they can pin that down more specifically, I can't imagine that would happen, but you can't rule it out.
I've got another COVID question. What about the subject of who pays for a COVID test if the test is required by the employer of an employee before coming back to work after exposure?
Then I think the employer should pay for it. If you're the one requiring the test, then I think you should pay for it. And I think the CDC language supports that.
What about the idea for people who don't want to get vaccinated in the workplace? If the employer says to them, that's fine if you don't want to get vaccinated, but you're going to have to be tested every 2 weeks and you're going to have to pay for it.
Yeah, I mean, that's one of the solutions proposed for, in some of the national employers we're seeing are taking that step. And I think that's okay. If you are encouraging people to be vaccinated and somebody absolutely refuses, that could be a form of accommodation, for instance, if somebody has a reason why they can't be vaccinated. But it can also just be if you're giving people the choice, I think you're entitled to say, then you're going to have to be tested every so frequently. And as long as, I would be a little hesitant if it was an accommodation issue to make the person pay for the test themselves. But if it was just because of personal preference, then I think the employee should or could be required to pay.
There's one other question I hear, and that is that if someone does not want to get vaccinated, and they may not have a medical reason for doing it, they just want to, can you require them to be masked full-time in the workplace? And what if they say they don't want to be?
Well, you can. In fact, that's what the CDC recommends that you do. For non-vaccinated people, they aren't really giving you a choice. They're saying that you have to be masked when you're in any indoor public setting. So I don't know that that's even a choice anymore if you're going to meet your obligations under the CDC and OSHA. And if they don't want to, then they shouldn't be at work. Not to be flippant about it, but you as an employer, you're going to risk violating your general duty under OSHA if you allow non-vaccinated people to be unmasked when you're in an area of higher substantial transmission.
Anything else you want to add?
I think you have emptied my brain.
Well, we've had a great crowd this morning. And for those of you that are interested, as you know, we did record this and we will have it up on our website at some point. It probably won't be today, but it probably will be tomorrow. And if not tomorrow, for sure by Thursday. I want to start by thanking Anne-Marie Story for joining us this morning with Rudman and Winchell. This is the second time we've done this together, and I think it works really well, and we have a good time at it. So, and I hope you all learned something and got some valuable information to carry back with you. I want to thank our premier sponsor, Rudman and Winchell. I also want to thank our webinar supporting sponsors. That's Casco Bay Food and Beverage, Central Maine Power, Eaton Peabody, and Maine Employers Mutual Insurance Company. I want to thank you all. I want to wish you all a great Labor Day weekend. And stay in touch and be on the lookout for our alerts around some of the carryover bills for the next legislative session. Thank you all very much.